IP has risen to the ranks of topics that are so important in law, but also in business. I think it's important to understand that our legal perspective is just one of many dimensions. And at the university, we started a cross-disciplinary master's program in intellectual property management and markets to look at finance, to look at design issues, to look at computer science issues and law altogether to understand how to monetize, to nurture, and develop the world of intellectual property. And I'm also pleased that we are taking upon that start. We are starting to launch a center this semester to study the empirical aspects of IP, whether they be in the valuation or in the legal domain. So important because IP has a dramatic impact upon the wealth of our businesses and our ability to compete in this global enterprise. So I think you're in for a treat today, and I'm delighted to introduce Ed Lee, who is the major domo of this affair. But before I do that, deans always have to make sure to finish with a thank you to the sponsors for the event. And so to do that, you'll see the signage, but we really are so appreciative of the support of our community to be able to put on this conference. McAndrews held, Morgan Lewis, Fish and Richardson, Cypher Shaw, Banner and Wyckoff, Hush and Blackwell, McDonald, Bain, and Clark Hill. And we have such wonderful firms here in Chicago that are vested in intellectual property. With that, Ed.
Thank you, Dean Krent, and I wanted to just echo his sentiments and thank the sponsors, the 8 law firms that are listed on your program on the front cover. Truly, without their support, we could not put on a conference of this size, this national conference, drawing experts from around the country. Secondly, I wanted to thank you all for coming bright and early for the first panel. It will be an exciting lineup of speakers the entire day, and I really much appreciate your taking the time to come to the first panel to start off the day. Each panel will be led by a moderator. The format will be the moderator will pose questions to the panel, and the panel will offer their views. The final 10 minutes of each panel will be devoted to questions from the audience. We will have handheld mics that will be distributing since we will be videotaping this for delayed view later on the internet. So please wait for the microphone if you have a question to ask the panel, and the timekeeper in the front will be keeping track of time for the panel. Without further ado, let me introduce our first panel, which will be analyzing the case Kappos versus Hyatt. Our moderator is Mr. Scott Burrow, who is an attorney in the Chicago office of Banner and Wyckoff. He went to the University of Wisconsin and earned his JD from the John Marshall Law School right here in Chicago. He is also an adjunct professor at Northwestern Law School, where he teaches courses in intellectual property litigation, and the Super Lawyers magazine has repeatedly listed him as one of the top Illinois lawyers in the field of intellectual property litigation. Scott?
Thank you. Good morning, everyone, and it's our pleasure to start off this terrific seminar. I have the privilege of introducing this first esteemed panel. To my far left is Professor R.T. Rai. Professor Rai is the Elvin R. Laddie Professor of Law at Duke Law School and a member of the Duke Institute of Genome Science and Policy. She graduated from Harvard College with a BA in Biochemistry and History and received her JD from Harvard Law School. Professor Rai focuses her academic research on innovation policy in areas such as synthetic biology, green technology, and drug development. To my immediate left is Mr. Aaron Panner. Aaron specializes in antitrust law, intellectual property, and appellate and Supreme Court litigation. Aaron has argued 3 cases before the Supreme Court and has been involved in a number of other cases brought before the court. Most recently, and pertinent to this discussion, Aaron argued the Kappos versus Hyatt case, where he represented the respondent. Aaron received his Bachelor's of Science from Yale College and his JD from Harvard Law School. Aaron also clerked for the Honorable Michael Bowden of the U.S. Supreme Court for the First Circuit, and also for Justice Stephen Breyer of the U.S. Supreme Court. Now, moving on to the Kappos versus Hyatt case. Before I begin the initial questions, let me just get everyone up to speed, so to speak, on the background of this particular case. When a patent office denies an application for a patent, the applicant has the opportunity to seek judicial review in one of two ways. The applicant can either appeal to the Federal Circuit, or the applicant can file a district court action against the director of the patent office seeking review of his rejected patent application. Here in this case, the inventor Gilbert Hyatt's patent application was rejected by the examiner. He also was rejected by the Board of Patent Appeals and Interferences. However, they did approve some of his patent claims. Mr. Hyatt, rather than appealing to the Federal Circuit, which is the most common route, he instead filed a district court action in the District of Columbia under Section 35 U.S.C. 145. In that district court action, Mr. Hyatt tried to introduce for the first time a declaration in support of his patent claims. The district court judge refused him to submit this declaration because he did not first introduce it to the examiner or to the Board of Patent Appeals and Interferences. So the district court judge ruled in favor of the director and effectively denied Mr. Hyatt his patent claims. The Federal Circuit, however, reversed the district court judge and held that Mr. Hyatt was permitted to introduce new evidence to the district court. The Supreme Court affirmed the Federal Circuit, and the Supreme Court held that the patent applicant's ability to introduce new evidence is only limited by the Federal Rules of Evidence and the Federal Rules of Civil Procedure. The court also stated that when new evidence is introduced, the district court must make de novo findings as to that new evidence and weigh it in relation to the administrative record that was before the patent office. Justice Sotomayor, filed a concurring opinion, and she emphasized that the court's decision, however, does not foreclose a district court from excluding evidence that was deliberately suppressed or withheld in bad faith. So with that as the background, I'd like to start posing some questions to our panel. And let me first start out with Professor Rye. Does the district court decision make it more attractive for a rejected patentee to seek judicial review by filing a civil action in district court?
I think to some extent, yes. And let me step back for a minute and say that I think this is a very interesting case because it poses a larger question with which the court has been dealing for a while, at least since Dickinson versus Zerko, which was decided in 1999, which is what is the appropriate intersection of administrative law and patent law. And I teach administrative law as well as patent law, so that's just my little speech on why I think this is a bigger case in the larger scheme of things as well. So yes, I do think that there will it'll be a little more attractive to seek. It should be on. Yeah.
See if you click this on. You have to turn this on.
Oh, of course I didn't put it on. Is this better? Better? Okay. So, just to reiterate, this is a very interesting case, I think, at the intersection of administrative law and patent law, an area with which the Supreme Court has been grappling for at least 10 years now, more than 10 years. I think that in response to your question, Scott, yes, I think we will see Section 145 actions becoming more attractive. That said, it's still more expensive to go the Section 145 route than to go the Section 141 route for two reasons. One, you have to go to a district court and then to the appeals court if the PTO chooses to appeal the district court opinion. And in addition, Section 145 provides that the applicant has to pay the costs of the appeal. So there is a barrier or a certain hurdle to filing Section 145 actions that I think does not exist for Section 141 actions. And finally, last but not least, I think at least for existing applications, the question of whether a Section 145 action is going to be useful is an open one, because presumably for existing actions that were filed prior to, or for existing applications that were filed prior to the decision in Hyatt, the evidence that was presented by the applicant was presented under the assumption that this was going to be probably their one shot at the patent office and one shot in terms of presenting evidence because they would take the Section 141 route. At least for existing applications, I'm not sure how much this changes. Of course, for new applications, there will be some interest, I suspect, in thinking about how to use this new avenue strategically.
Thank you. And following up on her comments, Erin, obviously pursuing an action in a district court under Section 35 U.S.C. 145, it's probably going to be a slower and more costly process. But however, is it more attractive than possibly filing a continuation or somehow taking that course of action?
Well, I think that as a practical matter, and I'm not an expert on prosecution, so this is sort of second or third hand kind of information, but it makes sense to me, and it's consistent with what folks who do prosecution for a living tell me. The vast majority of applications that are initially unsuccessful, the process for getting them through the office involves interaction with the examiner to address the examiner's objections, and subsequent appeals, which are pretty often successful. And then even in the event, I should say, appeals to the Board of Patent Appeals. And even in circumstances where such appeals are unsuccessful, there's possibilities for continuation practice and other types of practice within the office that allows for successful prosecution without resort to judicial review. So if you think about the vast number of applications that are filed every year, the number that lead to any sort of judicial appeal is quite small. Even the number of, out of the number that come in, the number of final rejections that are affirmed by the board is actually a fairly small percentage of what starts out. And so I do think that particularly in light of the kinds of expenses that Professor Rai was referring to with, in terms of taking any appeal, that the number of cases either through the 141 or 145 route is going to continue to be, those are going to continue to be fairly exceptional cases. The status of new evidence in 145 proceedings was generally understood for a very long time, I think, that new evidence was allowed in 145 proceedings. It wasn't exactly clear in what circumstances, but it does seem to me that if there were a significant advantage to be gained by pursuing review through 145 in a significant number of cases, this is an issue that would have been tested, it would have been pushed at an earlier point. So I think that it's really going to remain the exceptional case that goes up in, goes up, and that I think that it will still be, for most patent applicants, the primary remedy for an unsuccessful initial application will be to work with the office to address examiner's objections.
Following up on one of your points, getting to the substance of what transpired, Mr. Hyatt did submit a declaration in that case, and his declaration was really more in support of the claims because they were rejected in a written description. And so the declaration submitted, the question is, was that really new evidence? I mean, he was more trying to, I think, try and convince the district court that, listen, there is support in this patent application. So the question is, based on this Hyatt and Kappos decision, don't you think that, a rejected patent applicant should consider this course of action because they could get de novo review by simply submitting a declaration or evidence that really isn't new evidence?
Well, I think, one of the realities of Section 145 litigation is that we're not talking about a jury, we're talking about a district judge always. I think that a district judge is always going to, my instinct is that notwithstanding the formal, the fact that it's de novo review, and de novo means, de novo is sort of a term that can mean a lot of different things and carries different connotations. The critical point that the Supreme Court recognized, which, sort of as a logical matter, if you have a new record and you have new evidence, then the determination is de novo, sort of by definition. That record was not before the office, and so there needs to be a new determination. But the court also said that a district judge can look at what the new evidence is and determine, how much weight should this be given, what were the circumstances on which it was provided, sort of how new is it, to what extent does it potentially undermine the reasoning of the board and its decision. So I think as a practical matter, just sort of more generally, I think the possibilities for gamesmanship of the kind that you're talking about, try to put, take the 145 route, put in a little bit of new evidence to kind of blow the doors open and get a whole new consideration of the application, I don't think is what's likely to happen. I think as a practical matter, what's much more likely to happen is that there will be a focused attention on the points that were the basis for the rejection, and a presentation of evidence that allows a generalist judge to be able to make an intelligent decision about the validity of the points that were that were the basis for the decision below. And one of the points that we made that I think had some resonance was, if you think about the general rules about, if you think about why somebody might want to have an opportunity to present evidence in a 145 proceeding that they don't present before the board, before the patent office, it's really before the examiner. The board doesn't really take new evidence. But one of the reasons is that you're talking about a different tribunal. The examiner is supposed to be an expert with knowledge of a person skilled in the art, and so there's a lot of background information that presumably you're not necessarily having to prove up through evidence. Whereas once you're in the district court, you do need to provide perhaps that background or that perspective of a person skilled in the art or additional expert testimony. This particular case, the question of, is this really evidence, is it argument, really never mattered much, largely because the government had always insisted that this was evidence, and insisted on that, I think, for the pretty obvious reason that if it was argument, and this was all a question of legal argument, then it'd be de novo anyway. So they were, they tried to characterize it, they did characterize this as evidence, and it was always treated that way in this case. So,
Professor Wright, kind of a slightly different tact on a similar question. Do you think the Hyatt decision sort of creates a loophole by allowing patent applicants to get sort of a so-called de novo review at the district court versus going to the federal circuit route, which, the federal circuit route would review the evidence under the substantial evidence standard?
Yeah, I think there's, I'm a little more or less sanguine, I guess, as the case may be, that applicants might try to game the system a little bit. I do think there's a possibility of gaming the system. I think Mr. Panner's point that this is not before a jury is well taken, and if it were before a jury, I'd be much more worried about gaming of the system, because I think there are lots of games one can play with juries with new evidence. But since it's not before a jury, probably less possibility of gaming the system. That said, I think there is still some possibility, and I don't see why a clever applicant wouldn't at least think about that possibility of having some sort of insurance policy, if you will, in case they are running up against a brick wall at the patent office. I just don't see what harm there is in having something in one's back pocket to present before a judge, and hopefully with a generalist judge, be able to convince the generalist judge that this really does change the game in some way. Again, I don't think it's going to be there's going to be a huge influx of Section 145 actions. That said, I could imagine that for particular applications that are, deemed significant, even at the point of application, which is very early on, by the applicant for whatever reason thinks that this application is going to be really significant, Maintaining that kind of insurance policy, I would think would just be prudent. Not that it would necessarily be exercised, but I would think it would be a prudent option to maintain. And yeah, so the question of whether it'll actually be used as a loophole is an interesting one, and I'm not sure, but to have that loophole available, I think will be something that applicants should consider for important applications at least. Which I should say that, full disclosure, I was at the patent office as a policy advisor to Director Kappos when this case was initially being litigated. And I think that's the concern of the patent office, that even if it's not used as frequently as some might fear, i.e. people don't actually end up using the Section 145 route, nonetheless, it takes the PTO a little bit out of, it makes the PTO a little bit less of the main event, perhaps, or could make the PTO less of the main event. And it's part of, the case, I think, is part of a larger theme, and again, I'm going to try to broaden the picture a little bit beyond the case itself, a larger theme that's being played out in a lot of these cases that are reaching the Supreme Court about the PTO's power, including I4I versus Microsoft. To what extent do we defer to the PTO because it is an expert agency and an expert administrative agency? To what extent do the ordinary rules of administrative law apply relative to other principles that Congress may or may not have articulated in the patent statute?
Let me jump over to Aaron. This kind of touches on what Professor Rai just mentioned. It's been suggested that most applicants do not submit substantial evidence of patentability to the Board of Patent Appeals and Interferences due to the high likelihood that the rejections will eventually be withdrawn during the appeal process. Do you think this Hyatt decision sort of ignores the realities of that situation that does happen frequently at the Patent Office?
I don't think so. I mean, again, I'm not an expert on prosecution, so my sense for it may be a little schematic in terms of what the realities are once you're inside the office. But the main event in most patent applications is the work with the examiner and figuring out, at least as I understand it, is getting the examiner to approve the application. And it's already the unusual case that goes to the board. The board is not, unless there's been a recent change of the rules, as I understand it, the board is really not about so much taking evidence as it is about evaluating on the record that was developed, with the examiner, the legal validity of the determination, the validity of the determination by the examiner, the rejection by the examiner, and so I continue to believe that for most applicants, relying on the possibility of any kind of review is going to be exceedingly risky, and that the much more prudent course will be to do all that can be done to try to get the office to grant the application. I was interested when Professor Rai said, well, if you run into a brick wall at the office, then you have the remedy in court. And I do think that for an applicant who is, does not feel that they are, feels that the examiner is not open to persuasion, or an applicant who feels like there has been an inadequacy of process before the patent office, this does provide a remedy that can address those sorts of concerns. And it was interesting to me too that Professor Rai talked about the fact that she sees this as being at the intersection of administrative law and patent law, and I I always thought that this case was one that should be more interesting to administrative law professors than patent law professors, because it's almost like finding an insect frozen in amber. I mean, this is a situation where you have a review mechanism for administrative action that has been in place for, 175 years. And there just is nothing like it in the law that I'm aware of. And the whole idea of administrative law and review of administrative action didn't exist at all, just did not exist at the time that this statute came into being. And even when it was recodified in 1870, the whole idea that courts could sit and review of the action of the executive was considered no-brainer unconstitutional, could not happen. And so when Congress provided for this action back in the 1830s, there is no doubt that what they had in mind was the Patent Office is going to get the first crack at this, and then if you just can't get it and you think that you have a valid patent, you can bring a lawsuit in district court. Often they were between private parties because they involved interferences. But in the case of ex parte applications, if you had failed in the Patent Office, you could bring a new lawsuit in court, and have to be the same application you filed at the Patent Office, but you could take that application and try to prove to a judge that you were entitled to the patent. And it really, the idea that this was an administrative review proceeding wouldn't have made any sense at all to a lawyer in the 19th century, because it would have been gobbledygook. It wouldn't have made any sense. And I do think that ultimately that history and the depth of that history is what caused the court, both the en banc Federal Circuit and the Supreme Court, to rule the way it did, because it was just sort of undeniable that Congress had very deliberately preserved what was a very unusual, if not unique, but very unusual remedy for someone in this circumstance. And I think the reason for that historically, by this point, who knows how much attention has been paid to it when in the various recodifications. But it has been deliberately preserved, and I think that at the root of it is a really deep commitment to the idea of intellectual property, of the idea that a patent is property, and that if you have an invention and you've properly applied for protection of that invention, if you have properly applied for that property right, you really shouldn't be deprived of that property without a heck of a lot of process. And it really, so as I say, it reflects this idea in the 19th century that if somebody's going to take away your property, or you have a valid claim to property that's not being honored, we're going to give you a ton of process to vindicate that property right. And I don't want to jump ahead, but when you talk about the Morgan and the Butterworth case, one of the things that's going on in Morgan, if you read that case, is the case was trying to take away a property right that the Patent Office had granted in that circumstance. And the court didn't like, in other words, the court wanted to make sure that the property wouldn't be taken away lightly. And that was the reason that it talks about the fact that the Patent Office has given this person a property right, a patent, and we're just not going to take it away on a preponderance of the evidence or anything like that. There's going to have to be strong proof. And that actually is the idea that winds up, it's one of the very thick roots giving rise to I4I, because there's this idea that once you've got a patent and you have this property, nobody can take it away from you without a strong showing that you don't deserve it. And so it's to me, and that root is not really about deference. And Morgan makes some reference to, uses some language that to the modern ear sounds like it's about deference. But it's really talking about authority, I think. And it's really talking about the fact that the Patent Office gets to give these people property. And we're not going to take away that property on a flimsy showing. And we're only going to allow that property to be taken away on a very strong showing. It's not really an administrative law idea, although it does end up working its way into administrative law later. But indirectly and in some ways sort of that strain of it gets into administrative law a little bit by accident, I think.
So could I just follow up?
Yeah, go ahead.
So I do think that it is the case, I think Mr. Penner is exactly right, that in the 1830s when this idea of a Section 145 action was put into place, Congress clearly had in mind the principle that one could go into court and kind of almost start afresh. I think that is part of what was going on, and that's what convinced the Federal Circuit and the Supreme Court that notwithstanding the inefficiency of all of this, this is what Congress had in mind, and therefore, who are the courts, and as the Federal Circuit explicitly said, who are we to disturb the judgment of Congress, even if it's inefficient? And so I do think that that's pretty clear in both the Supreme Court decision and the en banc decision from the Federal Circuit. Where I disagree a little bit with Mr. Penner would be to suggest that all of these cases where a patent applicant is seeking a patent involve an already vested property right, because obviously that's not the case. In I4I, by definition, once a patent has been granted, the challenger who's seeking to invalidate it is seeking to invalidate an already vested property right. And that was to some extent the case perhaps in Morgan versus Daniels as well. Of course, when we're talking about an application, that's very different, and that's part of the reason why in Dickinson versus Zerko, if we go back to 1999, in that case, the Supreme Court, albeit in a divided opinion, was quite comfortable with applying an administrative approach in the 141 context, because there isn't a vested property right at that point. All is happening in that situation is that the applicant is seeking to get a property right. And in that case, in Dickinson versus Zerko, Justice Breyer made it very clear that we are talking about administrative review over the objections of those who said, well, the Patent Office has never been considered subject to the Administrative Procedure Act, because there was some evidence actually in the legislative history of the Administrative Procedure Act that initially the framers of the Administrative Procedure Act didn't want the Patent Office to be included, but that provision was taken out. So I think that it is correct that with respect to a patent that has been granted, and that was clearly what was going on in I4I, there's a sense that we're taking away a vested property right, and in that situation, the ordinary administrative rules of the APA are not what Congress thought should apply, because the Section 282 presumption of validity kicks in. But I do think things are a little bit different in the patent application context, and so I do think that's important to keep in mind.
And I agree. There's a difference. The point I'm making is, if you try to think about why would it be that there is this really quite extraordinary opportunity to appeal this up. And it used to be that you had to appeal it all the way, and then start a new action after your appeal in court failed. But why is there this extraordinary opportunity to bring a civil action? Why was it preserved? And I think it's because of the concern that if somebody has, albeit an inchoate, not yet vested, if someone has made an invention and therefore would, under a correct view of the facts and the law, have this property right, that we're going to provide them this rather extraordinary opportunity, not only to pursue it through the office, but also to do a civil action. But it's absolutely right that there is that significant difference, and I think it's the difference that accounts for in some ways for the language, why it wasn't strange for the Supreme Court to have language from Butterworth and Morgan living side by side, because it was, they were talking about two different things. Butterworth was talking about the fact that when you're, that under 145, or at the time 4915, it's a new action, new evidence, everything's new. And then in Morgan, talking about the fact that if there's no new evidence and you want to take away a patent, we're not going to do that lightly.
Touching on the Butterworth and Morgan decisions, Professor Wright, do you agree with the court's reconciliation of those two cases in this decision?
Well, aspects of it, but not other aspects. So Justice Thomas starts by saying, well, Morgan is not relevant here because that's an interference, and that it seems to me that's a distinction without a difference, because the appeal route for interferences and regular applications is the same under Section 145/146, and so that I think is a distinction without a difference. That said, I do think, and this is where, again, I disagree slightly with Mr. Panner, I do think that Morgan versus Daniels is not simply a case of a vested property right. It's also a case in which there is, at least in some of the language, a hint of what we would call in 21st century or 20th century parlance deference. So there is a statement in the case about this being something more than a mere appeal. It's an application to set aside the action of one of the executive departments of the government. And so, so I don't think the government, in emphasizing Morgan versus Daniels so heavily, was incorrect in suggesting it was a precursor to this more 20th and 21st century notion of deference to the executive branches of government. That said, the opinion in Hyatt, I think, is correct in saying that Morgan versus Daniels didn't involve the question of new evidence. That case just involved the question of what standards should apply to the review of the PTO's decision-making in a situation where no new evidence is presented. And I'm not sure, actually, that that piece of the puzzle is any different after Hyatt than it was before, in the sense that at least the Federal Circuit said substantial evidence review applies to, i.e. very deferential review applies to evidence that's already been presented. And I don't think anything in the Supreme Court opinion changes that. It's simply that as to the new evidence, there is this de novo review. So I think that Morgan versus Daniels is not really relevant for new evidence, and the piece of it that is relevant, which is that we're pretty deferential with respect to evidence that's already been presented. I think that is sustained even in the Supreme Court opinion.
So if I can just, one thing, I realize this is not the Supreme Court Administrative Law Review, it's the IP review, so I won't belabor it. But the one thing that is sort of interesting is that, you know, the language that you're emphasizing, what the court is saying is, when it says, you know, this is not a mere appeal and we're trying to set aside the action of an executive department, it's really hearkening back, I think, to a situation, to the general understanding at that time that if the executive underwent an action that was or undertook an action that was within its authority, the courts had no power to review that action at all. And all the courts could do was to entertain an action to set aside that executive action. And the basis for that kind of an action was extremely restricted. And so this idea of, you know, the administrative agency got it wrong, and so I'm bringing an action to show that they got it wrong so I can get relief from the courts, does not exist at that time. And so I do think that what's going on, this whole discussion in Morgan, and it's pretty hard, I think it's kind of a tangle, and it's complicated, and it's hard to understand. I'm not sure I understand it fully in terms of what was in the mind of the justice who wrote it. But you know, as I think you point out, the only way to get your head around what's being said is to try to put yourself in the position of a lawyer in 1894, and probably, you know, and a kind of old lawyer in 1894. And so thinking about remedies in terms of having an action, you know, remedies from executive action being limited to the idea that, well, if they've committed a common law tort against you, you might be able to sue them. And the court doesn't even kind of bite off this idea of, how can there be an appeal from the Patent Office, right? It's very strange. The whole statutory scheme that was put in place in the 1830s that kind of just stays there and still exists today is very strange because it's called an appeal, right? You actually bring an appeal from the Patent Office into court. And if you kind of back up and say, do we normally talk about appealing? There are some modern statutes that do talk about appealing administrative action to a court of appeals, but there's still something strange about treating the PTO as if it were a lower court in some way in that earlier decision. But in any event, as I say, I think the historical stuff is in some ways a little off topic in terms of how this is going to have an impact. But I do think that it really was the weight of the historical evidence that ended up mattering in this case.
So I completely agree. I do think it was the way to what Congress intended, which was a civil action. So I think that's right. And I think for that reason, it's probably rightly decided, the case that is, even though I have real objections to it from an efficiency standpoint and a policy standpoint, but that's not what the courts are supposed to do. They're supposed to interpret the law, or so we're told. But I think the interesting point, and again, I acknowledge that this is not an administrative law review, much as I love administrative law, but I think the interesting point, a larger interesting point that's raised by the case is the reality that the Supreme Court, when it gets these cases, oftentimes it gets patent cases, oftentimes has to rely upon really, really old precedent because it hasn't dealt with the particular issue in a very long time. And so these old precedents like Butterworth and Morgan were put into place at a time when people's view of the administrative state was completely different, as Mr. Panner points out. And so what the government was trying to do was trying to, I think, take Morgan and bring it into 20th and 21st century parlance of deference, which is how we think about post-APA, how we think about the administrative state. Whereas I think Mr. Panner's right that at that time, that's not how people thought about administrative law. And so there are these weird time shifts that go on because the Supreme Court really likes to rely upon its old cases, really old cases in many situations. And that comes up again and again in the because the Supreme Court has only recently become interested once again in patent law. It has to go back really far back in time.
And just to defend one thing about spending so much time on administrative law, I think there are lurking profound questions, and I'm not, haven't thought about it deeply enough to understand, how it's going to end up coming up. But the model of administrative review of judicial review of administrative action really has been applied to the PTO only to a very limited extent. And there's all sorts of actions the PTO takes all the time that are effectively unreviewable, even by people who are deeply affected by them. If you think about a typical situation where a patent is issued, if a license is given for a radio station and a competitor objects to that, they can bring an action in court and say, you shouldn't have issued that license and I want to challenge it. If you are a competitor of the person who received the patent, you can't bring an action in court to challenge what the PTO did, even though you may be very, very much affected by it. That idea, and that I think the PTO would hate that. And so I do think that this idea of to what extent is the PTO going to be treated as an administrative agency within this general administrative law framework, or rather are we going to continue to recognize that it's a very old institution that does a very special thing, and there's actually something in the history of the APA where they said something along the lines of, we started to look at the patent office. We decided it just wasn't, we just couldn't take that on, so we ignored it. I do think that it's going to be interesting to see to what extent there's continued efforts to sort of challenge the PTO's efforts to operate to a large extent outside of that ordinary framework.
So to follow up, I know for a fact, and I certainly have endorsed this approach in my writing, that the PTO wants to be an ordinary administrative agency. And after the America Invents Act, which institutes all these new administrative proceedings, I think we will see this situation tested over and over again. To what extent are the results of these opposition proceedings, these inter partes re-examination proceedings, these new ones, to what extent are those ordinary administrative proceedings which should be evaluated under the default rules of administrative law versus the older understandings of patent law, which didn't view patent law as being particularly related to administrative law. So I do suspect this is a case that is going to be part of a much larger tapestry of administrative law cases that will be invoked in the future with respect to these AIA proceedings.
Fascinating discussion concerning the interplay of administrative law, patent law, judicial review, and so forth. I do want to give the panel and the attendees an opportunity to ask you questions concerning this case. Is there any questions out there for Professor Rai or Mr. Panner? Go ahead, sir.
Maybe I don't even know anybody who has been in a Section 145 action after 37 years of doing this.
Well, now you do. The answer is that, yes, there's expert. It proceeds like a normal civil action. There's discovery to the extent discovery is required. It's probably going to be mostly, I think that most of the discovery will involve, in the typical case, just disclosure of the administrative record plus any supplemental materials that are related to it, along with if there's additional tangible things or things like that might be involved in an invention that were not part of the application. Those might also be something that would be subject to discovery. But for sure that in these cases there's going to need to be, or I think in the typical case, there's likely to be expert testimony. I think that the PTO will use experts. I don't think they'll put the examiner on in most cases, would be my guess. I think they will use experts, but I don't know for sure. But there have been 145. They're pretty odd birds, but they've certainly been done, and they do typically involve competing experts who will talk about what was the state of the art when the invention was. When the application was filed, what would a person of ordinary skill have understood from the application? To what extent was it an innovation? So yeah, that's and there will be summary judgment motions, and then there will be a trial in front of a district judge.
The only thing that again makes me less more sanguine than I would be otherwise, is that we won't have juries involved. And otherwise, I could see real nightmares arising.
And they are, the thing is, if you think about a typical patent application, obviously, it's very risky to invest a ton of money in an individual application because, and there certainly may be exceptions, but it's generally hard to anticipate what's going to end up happening if and when the patent eventually goes for enforcement. And so I also think that and that was something that you made reference to right at the outset, and I think it's quite right, is that there's going to be a significant hurdle to investment in these sorts of proceedings when, in the typical case, again, there's going to be the unusual cases where this is going to happen, but I think in the typical case, the best remedy for an applicant is going to be to try to work it out at the office.
Any other questions? Yes, sir.
I just have one brief comment about the examiners. I think that the PTO's official position is that examiners are not people with ordinary skill in the art any more than the attorneys are, even if they have a PhD and are actually a skilled person. You don't officially have that standing within the patent office. And as far as examiners testify, I think the official position has been in the past, at least from the standpoint of the party filing the lawsuit, they cannot call the examiner to be a witness. I don't know whether the patent office, their own, probably can, but I think they wouldn't want to do that, given their positions as far as the level of skill and the position, and not wanting the examiners to be subject to cross-examination.
That's helpful. It's interesting.
Yeah, thank you.
Yeah.
Any other questions? No questions? I know it's early. Somebody must have a question. All right, well, let me take the opportunity to thank you, the panel, this morning. Very insightful, very helpful, and do appreciate it. Thank you.